They are not there. Yes, sir. There are two companies.
Yes,
Yes,
they also can because they are participation in the yeah, they let us know.
Okay. So the problem to the final round is between two parties, two pharmaceutical companies.
IMOTEPH, and team 21 is representing Frey. Yes. Yes. That change. Okay. Team code 02 is representing Frey Biotech. I'm so sorry. Team code 21 is representing IMOTEPH.
Your team is MG02. Yes. Mine is 21. So we are representing Frey Biotech. We will be associated with pharmacy.
Ready? Both teams are ready. So I'm starting the time.
Good afternoon, gentlemen. We are here representing Frey Biotech, and we thank you for joining this negotiation so we can solve this dispute committee that has arisen between both our parties. I'm Samrat Murthy, and this is my colleague Aditya Nayak. And we'd like to take forward this negotiation on an amicable and a specific basis. And we have three issues that we'll be raising today, three primary issues. The first is regarding the issuance or the application of the patent that has been filed by our corporation. And the second is the issue regarding insider trading, section 15G of the SEBI Act. And the third issue that I'd like to do is the merger between our corporations and the way forward in the pharma industry. There are two corporations will have a role to play in this industry, in this country, and potentially beyond. And I would like to hand over to my colleagues.
Gentlemen, I'll just take 15 seconds, 15, 20 seconds of your time just to introduce so that both of us are on the same page while we sit on this negotiation table. So since we had talks going on with respect to the merger, and considering that merger would be one of the subjects of this particular negotiation table, we do have a term sheet and a letter of intent prepared, which we shall share with you. And as we progress through the negotiations, once we deal with the preliminary issues, we'll come to the term sheet and discuss the terms which are most favorable to us. So this is our roadmap, and we'd love to hear from you at this time.
Good afternoon, gentlemen. Firstly, I'd like to express my delight that we're finally able to meet outside of the court proceedings and outside of all the legal proceedings. I am Pranay, and this is Suhas, and we are the legal representatives of IMOTEPH Pharmaceuticals. Before I start, I'd just like to confirm that we have the complete legal authority to represent the needs of our clients and also negotiate any terms of the settlement in itself. Now, I understand that given the current situation of the parties and the amount of the business venture, the amount of money on stake here, tensions are probably running very high. But I'd just like to reassure you that we're in a comfortable environment, and the first and foremost ground that we're here to solve the matter amicably is already a common ground. Now I'd like to pass it over to my co-counsel to represent our interests here.
Thank you, Pranay. I would also like to thank you, Mr. Aditya and Mr. Samat, for once again joining us in this discussion. And I congratulate you both for reflecting on our ideas on finding an amicable solution. Before I begin to list down an agenda and get down to the nitty-gritties, I would like to acknowledge my client's sentiments with respect to a few matters. Mr. Jack is disdained by the state of affairs and the way the events turned out to be. What with the members of our board being placed under house arrest and the events which followed after that. So with all that which Vinay stated and what we're trying to achieve moving forward is that The company really envisions in being more forthcoming in the days to come. In light of what is being said, I would like to list down an agenda, and I'm keeping it short and simple for both our benefits. Firstly, we would like to discuss the nature of the claim and the contents of the claim, and how we can come up with an amicable solution. And secondly, we can discuss the future relations going forward.
Just seeking for clarification, this claim would be with respect to what?
The claims of the lawsuit
With regard to the patents
with the patents and the
and all
citation. And I'm also happy that you have mentioned the aspect of a merger and that you're looking forward to it. It's something which I think is mutual on both of us.
Just to seek some clarification with respect to this. Essentially, we have challenged the patent application. So, not necessarily is there a claim in the present context because this is a challenge. So, are there any other claims apart from the patent issue of what we seek to?
Of course, we will have to discuss the claims with regard to the insider trading and the claims that they filed with regard to 15G of the SEBI Act, as the co-counsel did mention. So we would definitely like to clarify certain aspects with regard to that. So, I mean, once we discuss these issues, I think it will be beneficial for us both moving forward, because we can't enter into a merger or any joint contract having these adversities.
All right. So, starting off with the first issue, I hope I'm audible to everybody. The first issue with respect to insider trading, I think that's the most adverse aspect that we are dealing with on this negotiation table. So, this is something. So, as far as 15G is concerned, this isn't the substantive provision, but this is the penal provision, right? But as far as the substantive aspects of what insider trading is and who can be involved in insider trading is in the PIT regulation, correct? So when we speak about the PIT regulation, specifically regulation number 7, as per this, the employee that was found guilty of sharing certain unpublished price-sensitive information stands on 2 grounds. Being firstly, the definition of a connected person has been given as per section 2D, sub-regulation 2 of the PIT regulation, where there's a concept of deemed to be connected persons as well. Now, while the former, being connected persons, speaks about immediate relatives, the deemed to be connected persons also involves all other relatives apart from the immediate relatives. Now, in that context, also keeping in mind the sum of money that has gone to that person's account or account linked to that person, rupees 1.5 crores. And all the trends that we see in the stock market basically amount to insider trading. Just want to know where you stand on that and how do you rebut it? Are there any other circumstances that you can point out?
Right. So, firstly, with regard to the PIT regulations as well, first thing, before deciding the definition of a connected person or the person who is actually, which you very casually called him guilty, with regard to that aspect, first and foremost, that is the important aspect is that there should be disclosure of certain non-public information, which is the primary contention here, is that there has been no declaration of any non-public information with regard to any of the research conducted between Frey as well as IMOTEPH. With regard to the further contentions, is that initially, according to 15G of the SEBI regulations, is ideally a penal legislation, and according to the legislation, it communicates any insider who communicates any unpublished sensitive information to any person with or without his request for such information, except as required in the ordinary course of the business under law. So this penal provision relates specifically only to the person who is communicating such an information. So we do not understand with what relation have you filed a claim with regard to that against IMOTEPH Pharmaceuticals.
Firstly, it's a settled principle of law that there's likely to be a value. Right? The relative who was involved or the person who was involved was an employee of your company. Right? He was part of your company throughout the top rank forum, that is of our company and growing with your company. Now, when this is the case, right, it is very clear and there is no apparent over here that that person was involved in insider trading. Now, considering the fact that you conceded that that person has to be held responsible, it is to that person that the company is involved in insider trading to which we claim. It's as simple as that.
Again, Mr. Aditya, I think we are circling back to the fact, you would just simply say that there is indeed a lack of evidence, concrete evidence linking the board members as well as the director with the claims which you are talking about at this point. So if there is sufficient evidence which you can provide from your part, I think that is something which we can look at.
Am I audible? Yes. So as far as evidence, the aspect of evidence comes, the very definition of unpublished price-sensitive information has a wide ambit. It's not restrictive. So it's very important. And when it comes to why the merger fell through, when the initial offer was made by a corporation, during the course of our board, deciding whether to act on that merger or what to reply, there were certain stock prices dropped of our corporation, and your stock prices went up based on formulations of our corporation that we were developing and researching, which your CEO had prior interest in. The CEO had expressed interest of the research and development team in our corporation, and was the main cause of the merger in the first place, the sending the request and the valuation that was based at that given point in time. So, given the wide ambit of unpublished price-sensitive information, it's not necessary that there are only a selective list. There's a member on your board who used to be the relative of the members connected in this transaction. And if I may turn your attention to regulations 2G2, its definition of insider means and includes in possession of or having access to. There are two folds here, two unpublished price sensitive information. So that individual clearly falls under this definition, and you're not just making a claim or not making any erroneous claim. You're just stating the facts as they're present to us and the legal point that we put forth.
And this person is not any ordinary employer, military
He's
employee.
a director of
part of your board.
See, first and foremost, we are not denying the relation definitely which exists, the family relation which exists between the employees. All right, we established that the relation exists by as relatives. However, such an existence of a relation does not necessarily imply that there has been disclosure of sensitive information. Firstly, with regard to the mergers, our CEO has been very forthcoming with regard to his issue, with his interest in being a merger. That's also one of the primary reasons we're here today. So, just the fact that a relation does exist does not imply that there has been a disclosure of information. And the only evidence that so far that we have the attention of is that there has been 1.5 crores, I believe, which has been sent to the account of one of your employees, which has been sent to the account of one of your employees. However, there is no
Your employees,
right. Sorry. With regard to that, there has been no paper trail as to where the money has originated from, where it is leaving as well. So there is no established paper trail as to a person being guilty.
And as far as stock prices are concerned, it can be attributed to a lot of things.
Indeed, but are you aware of the burden of proof when it comes to the use of insider trading? As to who that is best from?
I think we share the sentiments with respect to the burden of proof. But again, it comes back to without there being sufficient proof, it is basically hearsay. It's just an accusation.
We seek an objective answer, like who has the burden of proof to do insider trading?
It's definitely the party claiming insider trading.
Council, it's actually the SEBI, right? In the instant case, the penal provisions have been enforced by the Securities and Exchange Board of India. We do not have private police or we do not have private executive machinery to carry out the house arrest, right? So when a statutory authority has the power, and by the guidelines of the Supreme Court, they have the burden of proof, right? Which means that if the person, I stand corrected if I have voted towards guilty or I haven't, but he is still an accused, and as far as all the information is concerned, there's only point to one person. The circumstances are very clear that there was an increase in your stock price, decrease in our stock price. There has been a certain amount of money transferred to that specific relative's account and no other code as per the compromise concerned. So what we are stating at this point in time is that as per 15G is concerned, it does not speak about imprisonment or any other penal measure to be taken. What it speaks about is a penalty to be paid, which is mostly pecuniary in nature. So when we speak about a pecuniary penalty, I think this is something that we can settle upon, so we can give direction to this whole discussion regarding insider trading. So if we are on blocks with that, then we would be in a good position now to discuss negotiation, because we know that the burden of proof does not lie with us parties, but the Securities and Exchange Board of India. They have taken an action, and that action is not necessarily permissible by 15G, right? Because it speaks about a pecuniary penalty being imposed. A fine has to be paid, a penalty has to be paid for the damage done. When that is the case, what are you ready to pay? Or have you come up with certain terms, or should we go with the demand first?
I think we proceed with the demands first, because primarily, as from the point of view that we are coming from, is that the authority exercising of this particular authority has been fairly erroneous, and we do not agree with the method in which our shareholders are taken under custody and in-house arrest, etc. So, with regard to the compensation and how we move ahead, I'd say we move ahead in more of a collaborative point of view rather than a compensatory point of view. So, our primary offer with regard to this is first and foremost, we propose that Frey formally acknowledges and respects IMOTEPH's ownership and rights over this intellectual property. We will continue ahead with the testing, with procuring of the licenses, with distribution of the revenue, etc. And with regard to this, with every unit of the drug, if it comes out for commercial use, with every unit of the particular drug which is manufactured and sold, a certain part of the royalty will definitely be given to Frays. And we'll also be open to any collaborative in sharing of the information, R&D departments, etc.
Firstly, if the interpretation is this, that the application of a patent means obtainment of patent, that understanding is incorrect. At this point in time, even if we make a formal acknowledgement, that is legally and logically incorrect. Because unless and until you get from the patents board, you get an approval that you have this patent, only then we should become a holder of your intellectual property. So at this point in time, you have made an application, and we have made a pre-approval challenge of that application as per the Patents Act. That is where we stand at this point in time. So we are in no position to make an acknowledgement of your intellectual property, which we are disputing, because that basically defeats the object of this whole negotiation, which we are going to do. At this point in time, rather than bringing the acknowledgement of intellectual property aspect, let's say put on the insider trading aspect, take it off, then let's go to the patents part, and finally we look at a collaborative solution. Right now, we cannot look at a collaborative, but we'll have to be on the compensatory end because we have suffered a loss, right? And as per whatever is on record, it is potential that you will have to pay the penalty.
Talking about losses suffered in terms of shares, in the drop in share price.
What are shareholders are facing?
Again, I don't think we would like to attribute the drop in share price with whatever acquisitions that you have with between trading and selling. So, if you're talking about compensation, if you're talking about something we can decide upon compensation, I think it would be there on our end as well. So, if there is something which you can propose, which is collaborative in nature, I think we are more than happy to do that.
So, counsel, the reason we're at this negotiation basis, so we can conclude on a compensatory basis when it comes to the insider trading aspect, as to the losses suffered by our company shareholders due to the drop in price. The problem with proceeding with adjudication, formal adjudication before the whole-time member of the SEBI is, the whole-time member of the SEBI board has the power to impound the share or put the proceeds of the shares, the rise in share price of yours, in escrow until the dispute has been completed before the whole-time member. So this will take up time and effort, and money will be impounded. It will be in escrow until the dispute is resolved. The whole-time member does possess that power, and if we were to go to court, that would be one of our possible options. But we do not want that. We're here on negotiation, so we can approve on a mutual basis. If we go through the litigation route, neither one of us will, because your shares are impounded, and neither will we get the compensation until the dispute has been adjudicated and it's reached finality. And let's not get into the whole aspect of the appellate stage. So this is what we came to this aspect of going to litigation before the adjudicated body. So this is why we need to seek a compensatory measure that is mutually agreeable to both of us to avoid the entire process.
But then again, Mr. Samit, I think there are more factors which can be attributed to the dipping of your share price and increase in our share prices. So again, going around for a compensatory, going for a negotiation which is compensatory nature, I don't think it would be right on our part.
So as you said, there were other factors.
See, the mere fact that there was the occurrence of both companies approaching each other for talks about a merger, that itself could affect the share price.
There's a
And there is a
drop in share price.
Yeah, there can be a connection between one company's share price falling and the other company's share price increasing merely because they're competitors. See, first of all, it all comes down to the public's mindset when it comes to investment.
So as far as any logic is concerned, whenever a merger occurs or let's say an acquisition occurs, it's on the basis of certain synergies. If the synergies aren't identified, they shall not proceed with the merger. Now, merely because there is not a single case study which says that merely because in cases of acquisition there is a certain. But in case of a merger, because over here you are not acquiring the whole company but 45% stake. And there has not been, if you could point out, will be greatly help, but is there a case study that you can quote where the shares of the acquired
company, or I mean the company which is going to be merged has booked. Because in terms of acquisition, the acquired company's share price drops because of the huge financial costs correlated with acquisition of the company. But that is just ebb and flow of the market. You stated there are various other factors that have led to our share price dropping. Could you elaborate on those?
Yes. So with regard to the various other factors that we're talking about, initially, of course, it is established fact that we are competitors in the same industry, right? So when a patent is filed by a competitor with regard with regard to a portal invention that you are working on, and such a patent has been filed, obviously there when it comes to the public, and we have gone ahead with the testing process much before you have. With regard to the public's point of view, of course, there will be certain apprehensions regarding that. And as competitors, of course, our shares are going to rise. Consequently, your shares are going to fall. Uh, Along with that, of course, there could be other market factors which are also associating. The stock market is a very volatile in nature.
When we speak about the present context, I think the word competitive would be quite contradicting in nature, because the very facts or the compromise starts with the fact that your company has an apparent monopoly in the market. Now, this in itself is a contravention of the Competition Act, but we'll not touch upon those factors, right? So, when there is a big conglomerate and a small company, the small company is moreover advantaged by the larger market share that it's going to access after merger, and second of all, it also has the resources pooled in, right? So even by using any economic logic or any stock market logic, we cannot see our shares falling, because we are to benefit out of this merger, and that is exactly what the object of the merger was as per the company. So if this factor is ticked off, are there any other factors which you can relate to the
I mean, we're not exposed to determine the dip in the share market. All we're saying here is that your dip in the share market cannot directly be associated to us. Insider trading involves transactions of company securities or stocks or options. And we can, you have, SEBI of course has access to a blue records, and there has been absolutely no transaction with regard to your company's stocks or securities.
I think the interpretation of that provision is incorrect. When we speak about 15, the latter part of 15, what you are stating is 12A, where there is insider trading done with dealing in securities. This is not 12A. This is a case of 15G. And 15G can be correlated to PIT regulation. Now, under PIT regulations, one of the scenarios is where one of the competitor companies dealing with securities. We are not to state that you are dealing with our securities. What we are stating is that there has been sharing of unpublished price sensitive information. That is the thing. Well, a clause C deals with manipulation of shares with respect to insider trading. So it's with specific persons. But PIT regulation talks about manipulation and insider trading on a general basis, not person specific or company specific. There has been manipulation and insider trading. It just covers those regulations. So 12A, 12AB is not necessarily the right choice to look at. It's the PIT regulation.
I mean, we have definitely reached an impasse with regard to whether we take accountability for the dip in the share market. However, do you have a certain number you have in mind as compensation, or what are you looking for as compensation?
Right. So at this point in time, as far as our pre-money valuation of the company is concerned, it stands at $6 billion. Right. So that is exactly what we agreed upon as per the initial merger. It is $2.5 billion for 45% of the company, $2.7 billion for 45% of the company. The 100% valuation amounts to $6 billion. Right. That's what we are valued at this point in time. So what we seek in compensation is an amount of $1.5 billion. And certain alterations with respect to the merger. We have proposed certain terms. The term sheet of the letter will share it with you. Yes. Along with the LOI. And then we'll be in a better position to take it forward. You have the letter of intent and the terms of merger. Certain caveats have been added in the footnote and in that one.
We have taken into consideration your offer for compensation, but at the same time, I would like to go back and talk about Frey's initial offer, that is with respect to you backing out of your challenge with respect to the patent and going for a royalty deal. Is that something which you would be looking forward to? You could make back the money through a royalty deal.
Instead, what we would suggest as a counter offer,
because that is solely for the purpose of going for a collaborative approach than trying to right the wrongs by giving you a compensation. So that would be a little bit futile on our part as well. So do you think this is something which you can consider, and this is something we can negotiate upon?
We have not made a proposal. We have considered the proposal as the co-counsel stated earlier. We respectfully disagree with the proposition fetched by a corporation. In the alternative, we propose a merger of our corporations. The first merger fell through. We would like to revise valuation of our merger, and moving forward, after the merger has been completed, the patent application that you have filed before will be under the new corporation after merging our corporations together. Once IMOTEPH Pharmaceuticals and Frey Biotech comes together to form a new entity, the patent will be held by the new entity, not IMOTEPH Pharmaceuticals alone. It will be the new merged entity that will hold this patent.
We'll withdraw our challenge against them as part of the matter.
So with regard to the new arrangement between us, if at all we have, I would propose that we consider a cross-licensing agreement with regard to the specific cure of the disease currently disputed right now. So under the cross-licensing agreement, of course, we have a license grant where we're talking about a non-exclusive and a worldwide grant with regard to all of the inventions, especially with regard to disease, curing the disease with this PR technology, etc. A part of that will also include a royalty payments. That is, in consideration of the cross-license agreement, both the companies shall agree to accept a royalty payment structure with regard to the number of units which are sold. Beyond that, we also have a part of it which involves a collaboration and information sharing. Of course, since we are in the same business and we would like to collaborate, so we could definitely share some information, research, technical expertise with regard to these issues. We can also work on certain research projects and for mutual interest, of course. While all of this is in consideration, of course, you'll have a confidentiality clause. We'll have to make sure that whatever information or invention that we are currently going through and whatever information is there with regard to that should not be disclosed to the general public.
Given what you stated right now, the lateral half of your propositions can all be covered under the terms of merger. It's already there. It's already given in the terms of merger, as you proposed, in terms of collaborative effort, in terms of R&D, approach forward, development of new drugs, starting of new research and development, and expansion of the business, not just in the country and beyond borders. So all these aspects have been covered in the terms of merger. What you propose is a contract or licensing agreement of sorts.
Right.
Instead of taking that approach, the relationship between our corporations would end after a certain while when the contract expires or the tasks have been completed, whatever has been stated in the contract. What we propose is a merger is more definite and more long-term and more collaborative because interests are in the right place. They're synonymous. There is synergy of interest. Moving forward, all these collaborative efforts will make good use to a merger instead of a contract.
So even post the merger, right, the term sheet has been provided and there are terms to the share purchase agreement as well. Now, when we speak about the share purchase agreement, once it's at the execution stage, we'll also be restating the articles and the memorandum of the company. So as per that, we can also lay down the information rights as a memorandum. So anything we do beyond it will be ultra vires, right? It shall not hold as the act of the company. So your reputation will not be at stake at any point in time. But just going before that, as far as the royalty structure is concerned, what do you propose at this point?
I think if everyone's in consensus, could we ask for a private copy? We'd like to have a discussion for a minute. Right. So taking your considerations into interest. Initially, now we have two aspects that we like to focus on. First, of course, the merger. But before we enter into the merger, we'll have to find some collaboration with regard to how we settle the initial claim. Right. So what we propose is we currently go ahead with the joint licensing agreement with regard to the cure for the virus specifically. Right. For the current disputed technology or invention in question, we go ahead with the cross licensing agreement. We agree to share all of the royalties with regard to the manufacturing. We can either go ahead with the joint manufacturing or we can go ahead with separate. But we collaborate on that aspect. With regard to the merger, however, that will come at a later stage. We're definitely up for a merger. I mean, we as the corporation that we are more than happy to be collaborating with you and to pull in all of our resources together. So we would be going with the merger, but before that, I think we'd like to settle the claims at the earlier aspect.
When it comes to in terms of the royalty, what's the portion sharing?
Initially, what we had in mind was that we will like to share the royalty with regard to the number of units of the drug sold.
In what ratio?
Right. Our ratio which we had in mind was 2:3. 2 in the favor of IMOTEPH and 3 in the favor of IMOTEPH and 2 in the favor. Right. Yes.
And this is perpetually?
Yeah.
What's the duration?
Until the merger.
And what are the other terms in the joint licensing agreement with respect to sharing information, client information, all that?
Right. It would be a general clauses with regard to collaboration information, with regard to any of the inventions or anything with related to the certain cure, right? Any information, any research that comes up, any new developments that goes forward. We would like our R&D teams to be collaborating with each other and share this information in order to come up with a better alternative if in case any of them exist. So that is the only part of it. Of course, we have a confidentiality agreement. And in cases there is a dispute resolution, in case there is a dispute, of course, we'd like to include the clause with regard to mediation and probably arbitration will be our final recourse in this case.
Yes. So there are few issues that have been noted. Let's say we do move forward with this agreement, right? Let's say for a term of about 5 years or 10 years, whatever the time period may be. Let's say at the end of the term, we cannot come on a consensus to the merger. There's already been data sharing, research and development information exchange, and other trade secrets or other developments that we have started in the past that may or may not have been transferred to your corporation in the joint licensing agreement moving forward. So there will be an exchange of data, but there will be no prospects of merger in case it falls down. So it is definitely a lose situation for us, and it is very volatile.
You don't require us after you take
Yes.
all the information.
Once you get the information,
You are the bigger company.
The information that we're requesting is only with regard to the current cure and dispute. It is not with regard to all of the inventions.
yes, that will give you a substantial more increase in your market share of the corporation as it is. Whether it's one drug or multiple drugs that we will be developing through the joint license agreement, that is the question. Is the main concern we have is information exchange. Right? It shouldn't be in vain. As to when the merger falls through, we shouldn't be left with nothing in our hands, no information, or the other way.
We are, after all, giving this proposal in complete good faith, and we expect by the time the cross-licensing agreement works, we will go for the merger. And I don't think there would be, if we give a complete affirmation from our part, would that satisfy you for the merger?
The acts which are done in good faith is based on the outcome of the act, and if you see any colorable part of the act, right? So you even stating in clear terms as to you are entering in good faith does not necessarily guarantee that a particular act is being done in good faith. What we are suggesting, the same not just what we are trying to imply is that cross licensing is basically, as per our point of view at this point in time, is you buying time to process your patent application. That's how it looks like, right? Once you get the patent, obviously you have the complete license over it. License to you because you become the patent holder, and now you become the biggest player in the market, and from an almost monopoly, it actually becomes a monopoly. That's the situation of
Yeah. I would like to be unorthodox now and try to give you a sort of solution to your problem. What if we include a non-disclosure agreement towards the end? That is contingent that the merger does not happen. Would that satisfy your needs? With respect to the information that would be shared with respect to the cure.
Answer the question here is during the course of this agreement, let's say the agreement works out fine, we walk away towards the end of the merger, there is no merger. The problem here is you already have a grant of patent in your corporation scheme. Once you have that patent, you substantially increase your market share in that particular drug that cures that disease. That increases your market share, that increases your profits, increases the overall size of your corporation and your reach. And when you do walk away, or if you walk away from the merger, or if we were to walk away, we are left with nothing. You have the patent, you have the market share, you go from a near monopoly to a complete monopoly in the market.
As far as non-disclosure is concerned, we have the clause in the merger term sheet as well. Indeed. Now, as far as non-disclosure in a cross-licensing agreement basically means defeating the purpose of the cross-licensing.
As with respect to protecting your interest with respect to
It
information.
negates the very aspect.
Of information sharing.
So, what would you like to propose with regard to this?
See, at this point in time, the demand that we have is pretty clear. Right? So we can even look at this in a phase-wise manner. We can have another negotiation round where we can set the conditions preceding, conditions which have to be fulfilled on the closing date, and conditions subsequent to the merger. Okay, that can be decided on by both the parties, and we can enter into a share purchase agreement. Right, and in the course of this, certain things that we have to decide is first of all, post all the events that have taken place, what is the valuation at which the shares are being acquired? That is the very first point. Because at this point in time, because of the dip in our stock prices, we require a guarantee that even if the penalty is, negotiated upon, the price at which the shares would be acquired would be at the initial price. Because this would be an act in good faith, which we would consider from your end, because this would be in both of our. Because how this looks is, we were in talks for a merger, right? And then there was purposeful dipping of the stock prices, our stock prices, and then we move into a merger at a cheaper rate, so that we get a better deal. That's how this looks like.
So, with regard to the negotiating the terms of the actual valuation of the merger, of course, we'd be open to it. However, what is the point is that the merger is a future contingent. It is happening in the future, and we're not entirely sure of what would be the valuation of both the companies with regard to that. Probably your shares would rise at that point of time, or our shares would dip at that point of time. So we're not entirely sure about that aspect of it. However, we are willing to negotiate. With your initial valuation was 2.7 billion for a 45% stake. Would you still continue with the same contention?
So, with respect to this, right, at this point in time, even if we say a cross licensing is a transient move that we are making at this point in time, it will not help the valuation of the company. Because as per information sharing, you get our information, you already have information about the market, that is why you have such a market cap. Now, we are at a disadvantage, which means that our share prices or stock prices are going to plunge further. So at this point in time, as far as the merger is concerned, if you are ready, the pre-money valuation being at $7 billion instead, we should proceed amicably on this.
See, with regard to the cross licensing agreement, if your concerns are with that your revenue would dip by any means, or your share prices would dip, I really don't think that would be a possibility, because we'll be sharing the manufacturing, we'll be sharing the royalties and revenues coming out of such a product, and that would definitely result in the increase in revenue for both of the companies. And collaboration with a corporation like us will definitely increase your share in the market, which is, as you said, in terms of any merger, that is a likely outcome.
Now, what you are stating, right, the implications that you are stating are more likely to occur in a joint venture, because there's a degree of certainty of the relationship between the parties, or the duration is also certain. But when we speak about a cross-licensing agreement, it is mostly time-bound in nature. Right? Now, how shall we proceed after that? Will there be a non-compete that we shall not operate in the business or operate in the same market for a certain period of time? All those are under contention, and we don't have terms of the cross-licensing agreement as of yet. So there is a lot of uncertainty money over. So right now, another alternative, just to meet a middle ground, so that we don't be a sticklers for a merger, is a joint venture. But as far as the shares that you will be acquiring, will be less than 25%, because you would be an associate.
Is there any method that we can give you conformity with regard to the cross licensing agreement?
by conformity with respect to
With regard to the patent, with
if you have
regard
a
to
draft,
continuing
that
the
is the
farm,
most confirmed
We have a draft agreement that we can go through.
we would definitely be sending you the draft in our future sessions. Of course, we don't have one prepared right now. But yeah, the terms and conditions of that will be sent to you. We can probably further negotiate on the terms. But currently, what we want to do is have some progress with regard to reaching um, a method of a process that we'll follow further. So if you're okay with the cross-licensing agreement, and we can give you some conformity with regard to the patent and how you will be continue to be a part of our venture when it comes to the care of the disputed disease. And then maybe later we can definitely go ahead with the merger.
So we have an alternative solution that we'd like to propose. Both of our corporations, the condition precedent to this offer is that you pull your application for the patent out before we get this process started. We start a new corporation. 75% of the shareholding will be held by us. 25% will be held by our corporation. And the new company that will be formed will hold the patent for the same term. Application for the patent and the holding of the patent will be held by this new corporation. And once this corporation has run for about, let's say, 10 or 5 or 10 years or whatever the time period may be, then we can sit and talk about mergers that will give us more definiteness and more surety on our end that you will be willing to negotiate in good faith and move forward in terms of a merger. When we have majority of the shareholding, and once the corporations are merged, it wouldn't. It will be equal sharing because there'll be one corporation after the merger.
But this newly formed company would have a majority shareholding pattern of which 70% and 5% of it would be yours, right? So if we stated that the patent would be completely belonging to the company, it would mean the majority of it belongs to you.
No.
So of all that is generated from that company would be yours.
No. So just to apply it, stated corporate law, right? Like the company is a separate legal entity, some its members. So it is held in the company's name rather than in our name.
The directors of the corporation will hold no direct shares. The corporation, that is, Frey Biotech, will have 75% in the new corporation. IMOTEPH Pharmaceuticals will have 25% in the new corporation, which is very unfair.
So this is the alternative for a joint venture. But if you're going for a merger, we can stick to the earlier plan of sticking at 45
Let's stick to our initial offer.
at 7.
I think we'd be okay with regard to the merger. We're definitely okay with the initial settlement with regard to 2.7 billion as your initial valuation. With regard to your new terms as 7 billion.
Sorry, 2.5 billion is not our initial valuation. It's the price.
Right, with the merger, the 45% stake which is at 4. So we would be willing with that respect. But before the merger, I'd like to say it again and again that we need to find some alternative in order to ensure that we can share the patent rights with regard to the current cure dispute.
But in the present context, we do not have any patent rights. Right? That's what we're trying to
In a future contingent, if we want to collaborate further and invest in this particular technology and make revenue off of it, we would like to how do we assure you that you would continue to have a claim in such?
Let me draw it out alternatively. If there's no agreement on the patent, if we were to go into an adjudicating body to put a control of patent, the problem here is we do not wish to do so. But let's see the losses that both of our companies face if we do go that route. And if we cannot come to a consensus whether on a merger, a joint venture agreement, or the proposed new corporation that we stated, if we do go under section 25, we can get a stay on the issuance of the patent. And it will be so because you won't get an issuance of the patent, and neither will you be able to invest in other opportunities because both of our companies will be at loggerheads. That is problem number one. And the second problem is, even if they issue your corporation a patent, we can go to section 26. We can get that if we claim that has been stolen or there are certain infringes that have been made, we can get that patent transferred to our corporation. But these are long drawn out battles which we wish to avoid. These are our legal options which we do not wish to exercise at this current point in time because we have to reach a negotiation that will be on our terms. Because if we go before an adjudicatory bodies, we have to accept in its entirety whatever verdict they give. That is very uncertain for our corporation. That is why we're here. And we have presented numerous options when it comes to the patent.
Just one last thing to add to that. So as far as your patent is also concerned, the application, the clinical trials of the medicine has not reached the human trials yet, right? Which means that the medicine, in most countries, at least 3 clinical trials have to be conducted. Even as per India, as per CITESCO, we need 3 clinical trials. And then this is what we speak about human trials. At this point in time, it's merely confined to that. Right? So we haven't reached the stage where the product can actually be patented or be commercially sold. So a cross licensing would also mean a far-fetched idea because it's
There's still no
development
grant of
stage.
approval for your corporation. It's still at the application stage. And we are entitled by law to intervene at the application stage itself before any final order is passed in your trust.
Right, but we as a corporation, and I'm sure you also will trust, have some faith in your capability of coming up with the invention in the first place, right? So you understand that your cure will be the whole reason that you're applying for a patent and challenging the patent itself is because you have faith that your particular cure is going to work and you're going to create a product out of it.
Law does not operate on
Right.
Which is why we have filed for the trials.
Indeed. But if this moral sense is supposed to work in patent law, then
Right.
we would not be sitting in this table.
Sure.
Right?
So if
There
you
are
want,
certain compliances which are in place.
with regard to a confirmation with the patent, we would be willing for a joint venture. However, the shares, the ownership of the company, I think should go as 50/50. We do not see any particular reason as to why there should be an increased stake.
So if we are going for 50-50, that shall not be a joint venture because you will need to have less than 25% to be an associate as per the company is because both of us are Indian companies. So what we can look at is a merger itself so that we can incorporate into a separate entity. So there is no dispute regarding IMOTEPH and Frey. We are a single entity. We are unified.
There will be synergy of interests and both our interests will be aligned. There will be no conflict of interest.
There's no question of non-disclosure or anything of that sort.
There will be just one entity.
And that is the main purpose and merger tries to serve, and that is exactly why we started with, trying to go for a merger in the first place. So I think we're going around in circles with legal provisions and whatnot. So I think there is a paucity of time and we cannot go around with the fact. So let's try to come up with some sort of common ground.
Alright, so let's take off each issue at once as to how much we have progressed, and then we'll wind up in the remaining time we have. So the first one with respect to the insider trading, it remains unresolved as of now. The statements as per us, we believe that there has been insider trading. As per you, we do not attribute the difference of it. Second, with respect to the patent application and the merger, it is almost intertwined at this point in time because we went into cross licensing and back to the merger. So here we can probably reach a middle ground and then come back to the insider trading. Or else couple it all together. What we can do is that we can compound whatever amount you are supposed to pay, or let's say prospectively, if you were to pay for the insider trading, if proven guilty. What we can do is that instead of going to that extent, we can withdraw the complaint with respect to the insider trading, but we get a better deal with respect to merger.
We are not in favor of this proposed estimation, but we would like to find some sort of middle ground cross
So you would like to order the share
Yeah,
capital.
we would like to develop on the cross licensing agreement as well. That is okay.
The cross licensing agreement unfortunately is out of the equation.
So if we ask us to quote an amount as to compensate for all the losses that have been,
That is for the insider trading.
yeah, it's not something we can do.
See, with regard to insider trading claims, it's obviously we're not reaching a consensus, and we are very clear when we say that we're not going to be making any concessions or any compensations, either directly or through increased stakes in the merger. However, with regard to a merger, of course, I think that seems like the most likely outcome of this particular session, and we'd like to make some progress into it. So we are interested in a merger. But the terms of the merger, of course, can be negotiated. What is your initial valuation, and what percent do we continue?
The pre-money valuation was $6 billion, right, as per the component. But we'd like to proceed at 7.
See, the thing is, firstly, the pre-value valuation of a company is not the current valuation of your company. We know that the share prices have dipped considerably, and
As a
purchase,
result of the insider
Due to
trading.
insider trading.
which remains disputed.
For the SEBI to know, not for us.
Right. So like I was saying, so with regard to the initial pre-valuation thingy, we would probably continue with the 2.7 billion for 45% stake. However, with your increased valuation of 7 billion, I don't think we would find consensus with regard to that.
The only middle ground over here would be with respect to decrease in the share. Right?
we reduce it. So we should reduce, we can offer 2.7 billion at $6 billion, but we reduce the shares to 40%.
Before we head to that, can I ask you on what basis or what thought process do you have with regard to increasing the valuation to 7 billion?
So first of all, the increase in valuation is specifically with respect to what will unfold post the dispute of the patent and once the insider trading is over. Now, while you're positive on one end, as you stated that we file for a patent in the first stage because we are sure that the patent stage is going to be, we are going to obtain patent, right? At this, on the other hand, we are also quite positive of the proceedings with respect to the insider trading. Now, if these two events are proven and they turn in our favor, the valuation of your company is also going to significantly come. This means that the synergies are also multiplied. Based on that, we hold authority to increase the valuation. But let's say if you do not want it at an increased valuation, the middle ground is we keep the valuation constant, but the shareholding increases.
Right, but if we move forward with the merger and if you have already expressed your desire that you would be able to withdraw your challenge with regard to the patent and also with regard to the lawsuit in insider trading, I don't think that would lead to any contingent situations
So
that
this
would
is happening within closed room, right?
Right.
So while we step out of this room, at this juncture, we do not have anything on paper to say that one party is going to withdraw or one party is going to comply, right? So while this closed door meeting is going on, this is the status.
Right. So if we were to reach a consensus, if we were to write down an agreement with regard to how we settle our legal claims, if we were to, if I request you, in fact, if we were to write down an agreement with regard to withdrawing of the patent and withdrawing of the case against insider trading,
You have to withdraw.
the return the challenge to the patent, right? And we can the patent can be filed in a joint capacity
Sure. As a merchant, entity, right?
as a merchant.
That was good.
So with
Right.
Right. So if that were the situation, then I think we should still we can move forward with the initial valuation of the company in itself at 6 billion and 45 sorry 2.7 billion at 45%.
So as far as the there are two roadmaps that we provide at this point in time. I think we are very close at this point in time towards the resolution. This is in the best interest of the parties at this time. So one offer, which is already stated, is with respect to the reduced shareholding at 40%. We are still open to negotiating a middle ground over that, but not at 45%. That is the first medium. The second medium that we are ready to do is with respect to the rights that we will share as a merged entity. Okay. So as far as the dividends or the liquidation rights that we are going to get as stated in the term sheet, those are going to be in our favor. That is the seller's favor, we the seller, in our favor. And you should take care of so this is the second point is at the same valuation, the same percentage of shares. But 45% shares, you get at 2.7 billion, you get 45% shares of the company. But as far as the expenses with respect to this merger is concerned, and as far as the indemnity is concerned, that is something that you are going to be borne by your company.
In your terms of merger, you've already stated that the registration expenses and all of the legal expenses will be borne by the purchaser himself.
Correct.
Which in our case is
yes.
in
You are
the- right.
So a term sheet is basically a suggestion. So that's open to discuss.
Sure. I think
This works for you?
I think this works for us. We will be willing to go in this direction. I mean, of course, we have certain unresolved issues with regard to insider trading, but I hope we've reached some consensus with the fact that we are going to withdraw your challenge to the patent as well as withdraw the lawsuit with regarding to
So
insider.
the parties will be held in the new corporation.
Yes, the current.
But we'll be talking the insider trading side. We'll be withdrawing.
Sure.
At this juncture, if we can revisit the terms and start it off with insider trading, I think with the forthcoming of the merger, we are ready to drop the complaint with respect to insider trading and compound it. Second of all, with respect to the patent claim, we are ready to withdraw the challenge petition that we are filing. And thirdly, we shall be merging into an entity where the expenses with respect to the merger as well as the indemnity should be taken care of.
And we'll be entering into the merger with 2.5 billion shares at 2.5 billion valuation at 45% stake.
2.7. 2.7. The original deal for based on valuation we brought after the deal.
Yeah, I think I'm glad we reached some.
On that note, I think we can shake hands.
Yeah.
How have you done it?
So I'm happy. In the website system.
So I'd like to know from Frey Biotech concepts. What was your partner?
So before we start this negotiation table, there were a few things that we were certain about. The first one was with respect to insider trading. There was a certain amount of compensation that we sought to keep from them, if at all the merger was not fulfilled. So at this juncture, the partner to be clearly put. Firstly, with respect to the insider trading, a claim amount was made. Second of all, with respect to the terms regarding the patent, it was clear that we are going to challenge it, and the challenge shall succeed. Third, with respect to the merger, we were clear that we wanted at the original valuation and not based on how the stock traded. This is what we are saying. And the Zopa was basically $1 billion more, but I think we have got a deal considering the fact that it's at the original.
Zopa was between
Zopa was what we set initially at $7 billion,
Correct.
but considering the precedent with the drop in the stock prices, we were pretty happy with having 6 billion as our goal.
Now it is set for 6 billion.
Yes, 6 billion is the valuation of the company.
Okay, with respect to the second thing that's about the patent application, how you are confident that you are going to win? What is the basis for that?
So the patent application was filed by their corporation when they had initially proposed a 40% stake in our corporation to purchase agreement. While our board was considering this agreement, they went ahead and filed the patent application during the course of these negotiations. So there was a rise in their share price and there was a drop in our share price respectively. So based on these aspects and the drug that we were developing, the CEO of their corporation had a very close eye on that aspect, on the drug and the research and development aspects of our corporation. And that was the main reason why their corporation had sent a letter of intent in the first place, acquiring 40% at a 2.7 billion valuation. So based on that, and the board of members who was inquired into for insider trading, based on all these information, we would say that we would oppose their patent application. And we had good grounds as to say that this was not acquired legally, and there were certain discrepancies in the manner of the filing of this patent application. And based on those grounds, we had grounds under 25.1. Those are the more generalized grounds that we were going to appeal to, and not 25.2 or section 25.2 or section 4 of the Patent Act. So they were on 25.1. And even in the interim, if an application was passed in their name, and if there was a grant of patent in their corporation's name, we would go through section 26, that is obtaining of patents to the comptroller. Once it's been assigned in their name, and if we successfully prove before the controller of patents that it had been wrongfully obtained, the patent would have been transferred in our corporation's name. So we had these legal routes, these legal routes at our way. And on the basis of this, we made the patent sale.
Well, this question is for IP, IMOTEPH concerns. Was there any special reason why you are starting observation was to tell the other party that you have complete authority from your clients?
In our negotiation setting, the initial authority, the initial establishment is that as counsel, we have authority from our from the legal corporation that we are representing to make certain claims with regard to negotiation, to settle the claims of the agreement, etc. So we did have authority. Of course, our clients, of course, have given us our exact partner as to how far we should proceed. So with regard to as far as we can consider, of course, we had complete authority. If we did go beyond that scope, of course, we have to consider.
So you are of the view that given a chance, you would say you too have limitations.
Yeah, sure.
You work within the limitations, so it was not a complete authority. Both of you, when it was talk about insider trading issue, both of you were harping upon law, its interpretation, sometimes on evidence. What's your take on that? Do you really have to talk on what are the evidences we have to show to the court to say that even is it required?
So from our part, there was clearly a lack of evidence which connects the board of directors and the director himself with any of the claims with respect to investing. So our claim, our contention in the first place was to say that if you have a lack of evidence, and based on that you cannot accuse anything without evidence is accusation. That was our idea.
This is to EFB. A small observation, which goes a long way, I believe. However, deeply you are immersed in the homework that you would have done, which you want to bring on table. You cannot dispense with both counsels greeting the other two counsels, which got missed. I'm sorry, this is almost a feedback. I wouldn't have come for this at this stage. Anyway, I must tell you, we have discussed as three judges. Your assessment on other counts has happened. Only discount, only discount it has to happen. That's why we are conducting this session in the presence of both of you. This is for the second counsel from SVFB. Why are you insisting on joint application for patent? Any special reason?
So it is not a joint application, but an application made by the merged entity.
New entity.
So the rationale behind this is considering the fact that they already have the market share. They have the larger market share, and as per the mutually agreed fact, they have an almost monopoly. So at this point in time, as a company, if we merge, we basically get access to bigger markets. Our resources are also pooled, and at the same time, we'll be able to expedite the process of clinical trials or any other things that we have to seek an intellectual property right. So that is the rationale behind it. It's capital infusion with research and development abilities of the merged entities.
One last close observation, but I want to have your understanding about it. If it is deliberately done, I want to know why it is deliberately done. In the course of bargaining, you went on to say the reason we are on this table today is that we are uncertain of what happens to our case with respect to insider trading. Was that required, and what was the strategy to come up with that weakness, if I may say?
So the statement was made primarily based on good faith, because no matter how solid we think our case is, based on evidence or other factors, and no matter the precedent laid down by high courts or statutory authorities or how good the law is on our side, there's always a level of uncertainty before an adjudicatory authority. Because when it comes to corporations, especially corporate investing, time is money. And no matter how long.
I would appreciate that.
Yes.
Had you said that we have all the chances of winning and only winning, but time matters.
Yes.
Hence we are here. I would have appreciated it.
That was the rationale behind it.
Alright.
I just have one clarification to ask for this team 21, I suppose. Now, why were you not insisting on JV when there was a middle ground they offered?
Regard to the JV. So initially what we wanted was, as a partner, what we had was a cross-licensing arrangement with regard to the distribution. And we as a corporation, of course, are pushing for a model because we wanted to collaborate with them and we've already expressed concern of that. With regard to the JV, we wouldn't be entirely sure. I mean, it would be a full-time process if we went ahead with the merger anyway. Because as a merger, of course, we will automatically be going ahead with holding it on the So with regard to another JV, just for the application of the set agreement, wouldn't have any problem. So with merger as in our mind, in the back of our mind, that we are going to take a merger at some point. We didn't think that it was actually.
Also, you spoke of collaborative model and you said compensative model when the discussion came up. They were only looking at compensative. You were pointing out a collaborative. So, what would actually the main perhaps the points for negotiation, if at all you had to continue on that collaborative model? One is the use of patent you said, but that is in dispute now. You can't claim it. And then there is no advantage for both the companies because until that matter is finally decided, neither of the company is said to have any advantage per se. So what other things, for example, you come up with new research, R&D, that's one of the collaborative model. But did you have anything more within the scheme of this entire, the problem that you have come across?
So our industry specifically what we focus on is something called a pseudomedicine, which is very different from what Frey technologies usually contain, which is the traditional form of medicine. And that is why with regard to pseudomedicine specifically, that is the entire reason why they approached us with this. And that is why we wanted to, that then would be our other avenue of approach. With regard to this, if we collaborate further with regard to a specific aspect.
And this team code 2 did not mention anything about authorization by the clients. So is there any particular reason specifically you did not mention?
Correct. So when we speak about a merger, like if we are sitting on a negotiation table for a merger, it would be incorrect to state that we have all authorization with respect to conducting a merger with that matter, because all of this requires the assent of the board of directors and board of directors of both the parties involved. Now, at any point in time, we still have to revert back to them. So all the authorization that we have right now at this juncture is to represent the party and represent the interests of the party. So it would be incorrect to say that we have the authority to take decisions for that matter. For all of which we have to revert back to, and that's the reason why we omitted that particular portion.
But in the same stride, you also went to the extreme stance, saying the term sheet is open for negotiation.
Indeed. So as far as a term sheet is concerned, the whole object of it is to provide certain degree of certainty with respect to what will be the terms of this whole synergy that we have. So if we have nothing to discuss on the table, if we merely say that if both of us join together it will be advantageous, it would not reach much avail, and this whole session would not be fruitful in nature. So we have not come up with an agreement itself. We have come up with a term sheet citing terms for different agreements that we'll enter into. And that is the reason why we came with a term sheet, so that we can add a degree of certainty. Because they did not have terms for a cross-licensing agreement. So instead of putting the other team in the shadow, we decided to come up with them.
And what are your challenges on their patent?
So as far as their patent is concerned, now just to differ from what the other side said with respect to them and us being in two different segments, that is incorrect. We are primarily in the pharmaceutical sector, and with respect to moving from one product to another, based on the opportunity in the market, there is enough space. Looking at COVID and looking at other epidemics, etc. So when we speak about such a context, they were in talks with us for a merger, which means that there is some information sharing in that process as to how we can synergize. Now, after which, whatever events have unfolded, it clearly shows that this was basically transpired to handicap us in a manner. One is dip of the stock prices, second is filing the patent application. So clearly, we wanted to challenge this patent application. It is allowed under law that pre-approval we can challenge that.
I would like to know from Council of Biotech, what made you to settle down for the this amount of 6 billion? You started with the 2.5 billion and just went to 6 billion. Did you have any ZOFA for that?
No, 6 billion is the valuation of the Frey Biotech.
6 billion was the initial valuation. 2.7 billion was valuation of 45% stake that we agreed to. It was the initial offer that we agreed upon. 6 billion was just the entire valuation. We were still not agreed.
Okay. And when it comes to the adopting a different style of negotiation, you being a monopolistic, almost a company with a monopoly in the market, why you did not adopt the competitive style in the negotiation? As per my observation, throughout the negotiation, you were having a cooperative style. What made you to adopt the cooperative style instead of competitive style?
It's mainly with respect to how the confidential information is being provided, because none of their points then with respect to the SEBI guidelines and corporate information from the target officer, everything was in our fault. So it was our main aim to go for a collaboration rather than go for any sort of compensation. The moment we try to allow for a compensation, we would try to, even though not actually speaking, we would try to at least hint at. So that was not something we were looking at.
And to this Frey Biotech, instead of making a initial opening big demand, why did you ask the other party whether they have any proposal? Had you made a big demand, it could have created more pressure on their side. What was your strategy?
The strategy was, at this point in time, the penal measures that were taken against them were not in line with the provisions. So we actually wanted to understand whether they are on the same page with respect to understanding the specific provision, so that they know that the penal provision applicable over there is on pecuniary terms and not in terms of imprisonment, etc. So once we could understand, and whether they had any idea as to how can they value the demand that we are making. So the calculation also comes into the picture. So only then we would be in a position to make a demand and explain the breakdown so that both of us are on the same page. So that's the reason why we wanted to hear them out to see that they're on the same page.
And also given we wanted to know their rationale behind the valuation or the potential loss caused due to insider trading. We also stated that the full-time member has power to bound another aspect. And moving forward, the main objective was a merger, because we wanted to be both parties at a consensus. We didn't want to keep going back and forth with numbers, because we have suffered these many losses, our share price has dropped so and so. Because we wanted to come in a consensus with insider trading and then move on for the merger, because moving forward, the merger will be moving forward together. So we wanted to move forward in good faith and in the same direction.
With Prasad.